हेलो 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 हेलो
भैया यही है, इधर रख दो इसको। जब इसको पढ़ोगे ना, यहाँ से पेज पढ़ उनको आसानी रहेगी ढूंढने में। अच्छा, यहाँ पे सेक्शन ढूंढने मुश्किल होता है, समझ रहे हो? 44 पता नहीं चलता, 44 और वैसे हाईलाइटेड भी नहीं है। सेक्शन पेज बोल दोगे तो उनको लगेगा नीचे लिख दो, ये वाला करना, सर्कुलेट कराऊंगा क्या? ये नीचे लिख दो ना पेज नंबर। 2 सेकंड। इसके सबके एक सेकंड पहले काट दो सबके। अच्छा हाँ, नहीं छोड़ो। अरे वो कहो अपने को दे, वो लोग अपना खुद का हो गया, अपन फिर भी दे देंगे, उन्हें लगेगा तो एफर्ट डाल दिया बंदे। ये हाईलाइटर होता है ना, उनको हाईलाइटर मिलता, खुश रहते हैं। मांगो वहाँ से, पीयूष से पूछना। पीयूष यार, there exists a highlighter.
Highlighter से
हाँ, can you arrange one?
कैंसिल है। हेलो ओके, आपको कुछ चाहिए? ये मेरा छुई को भेज दो।
काट दिया।
हेलो हेलो हाँ
machine तो पेपर में मशीन आते हैं इन्वेस्टिगेशन बोलते हैं ना पेक्युलर
Hello
स्टैट्स
everyone, I
मॉडिफाई
request you all to put your phones in
मीटर
silent.
क्या बोल रहे हैं बेटा? अभी किसी का इंस्ट्रक्शन
साफ रखो इसको उधर रखो उसके बाद
I request all of you to A very good afternoon to one and all present here. Today I, Vanshika Man, on behalf of HPNLU, welcome you all to the final session of the 3rd Himachal Pradesh National Law University National Moot Court Competition held in association with the National Human Rights Commission. I'll hand over the stage now to the Court Master to begin with the session.
Greetings of the day, everybody. Today, I, Soumya Sharma, greet you all on behalf of the Moot Court Committee, and I will be the Court Master for this session. For the session, we have team number TC 312 as the petitioners and TC 301 as respondents. I request speaker number 1 of both the teams to kindly apprise me with the time division.
The counsels for the petitioners will be dealing with 24 minutes of the court's time each, and we reserve 2 minutes for the rebuttal.
The counsel for respondents would take 22 minutes, the counsel 1. The counsel 2 would take 25 minutes and 3 minutes for rebuttals.
All the participants are requested to maintain the decorum of the courtroom. The teams are requested not to reveal their identity as well as the name of their institution while the session is on. And with the permission of judges, I now request the team representing the petitioner's side to kindly begin with their arguments.
May it please the court. This is counsel number 1 appearing on behalf of the petitioners in the case of Marwarden versus Union of Indica and others, and Michael Joseph versus Union of Indica. The counsel seeks the court's permission to collectively address the bench. Your Lordship. Much obliged. Your Lordship, the counsel would like to take 2 minutes of this court's time to brief the facts of the case. Marwarden, a well-reputed poet in Indica, is a member of Zatali religion, and he published a story in poetic form from Shubhavani Prakashan. In one of the verses, he characterizes the beauty of a woman fictional character, and in another verse, he describes a sexual act in which she involved with her paramour. Abhilashi, an NGO, filed a writ petition before the Jatala High Court and argued that the poem was obscene and an offence under Section 272 of the IPC. As the issue garnered attention, various protests broke out in Chatala, and one of it became a riot in which people used Molotov cocktails. Following this, Union of Indica imposed internet ban in Chatala and arrested Mr. Michael Joseph under Unlawful Activities Prevention Amendment Act 2019 for using Molotov cocktails. Zatala religion prohibits its members from making lascivious description of women, and it is recognized by the Zatali community members, Management and Regulation of Conduct Act 2022. A group of Zatali members moved to the High Court stating that Marwarden violated the said act. The High Court declined to provide any relief to the NGO or to the Zatali members and held that Marwadan has not exceeded the legitimate domain of expression. The High Court did not interfere with matters such as religious sentiments, internet ban, and validity of UAPA, stating that such matters have to be intervened by the Court of Highest. The Supreme Court then clubbed the petitions filed in this regard and constituted a 13-judge bench to decide the matter. If your lordships are clear with the facts, the council would like to proceed with the issues. Your lordship, this council will be dealing with 3 issues. First, whether the Zatali Community Management and Regulation of Conduct Act 2022 is ultra vires the Constitution. Second, whether there exists a hierarchy in the idea of fundamental rights. Third, whether the author's exercise of right to freedom of speech and expression violates the general standard of decency and morality. The council submits to the jurisdiction of this honorable court and seeks permission to proceed with the issues. Much obliged. Your lordship, the council submits that the Zatali Community Members Act is indeed ultra vires the Constitution. Section 2 of the Act prohibits certain restrictions to expression, and Section 3 punishes violation of the same. And the Act in detail is presented before the bench as Annexure 1. Your lordship, the council would like to substantiate upon the unconstitutionality of the Act on 4 grounds. First, the Act violates Article 14 read with Article 15 Clause 1. Second, the Act contravenes the principle of secularism. Third, the Act imposes unreasonable restriction on freedom of expression. Fourth, the Act is void due to its vagueness. Proceeding with the first limb of the argument. Your lordship, the Zatali Act violates Article 14 read with Article 15 Clause 1 of the Constitution. Section 2 of the Act prohibits its members from making derogatory expressions against women in public, initiating public discussions about intimate acts that persons involved in, and general representation of women in such acts. It also mandates respect towards women and women. Your lordship, prohibition of derogatory remarks against women is a rule of general nature, and it is a general expectation casted upon all individuals irrespective of religion. It is evident from Section 2 that the Act in its fifth and substance it mandates a general conduct. If it were the intent of the legislature, your lordship, to enact a legislation to protect women against derogatory expression, it should have been made applicable to throughout Indica and must not be confined to one particular community alone. The consequence of this confinement is that derogatory remarks made against women by any non-member of Zatali community is left unpunished unless it is attracted as an offence under any other law. Whereas if the same remark is made by a member of Zatali community, he is liable to be imprisoned for a period of 10 years and fined up to Rs 25,000 under this Act. Therefore, there is no intelligible differentia, and the classification between members and non-members of Zatalism is solely based on religion. Thereby, this violates Article 14, read with Article 15 Clause 1 of the Constitution. If the court is satisfied with this limb of the argument, the council would like to move on to the second limb of the issue. That is, the Zatali Act contravenes the principle of secularism. At this juncture, your lordship, the council would like to draw this honorable court's attention to the distinction between a religious state and a secular state. A secular state has a negative obligation of non-interference with religious practices. The obligation casted upon a secular state is negative, and neutrality is the uniqueness of any secular state. A religious state, on the other hand, is having a positive obligation. There is a positive duty upon a religious state to take up the religious tenets of a particular religion and enforce it into its laws. If the intention of the legislature in this particular case is to enforce the tenets of Zatali religion, then it becomes a religious activity in contravention to the secular duty of the state. Moreover, your lordship, the Supreme Court, the Honorable Supreme Court, in the case of Lily Thomas versus Union of India, stated that religion refers to matters of personal belief of the relations of an individual with what he regards as his maker, creator, or cosmos, and what he believes to regulate the said relationship. This connotes interpretational autonomy that freedom of religion holds in the Constitution. By dictating a conduct that the state thinks fit upon its own interpretation of the religious tenets, curtails the interpretational autonomy of the members of Zatali community. If the court is satisfied with this limb of my argument, the council would like to proceed to the next limb. Much obliged, your lordships. Your Lordship, proceeding to the third limb of the argument, the Council would like to state that there is no objective standard of interpretation and the Act is void due to its vagueness, Your Lordship. The Council would like to refer before this Honorable Court the case of Shreya Singhal versus Union of India, wherein the Supreme Court mandated two essential elements for any law that curtails expression, Your Lordship. One, there must be an objective standard of interpretation. Second is the mens rea. Your Lordship, in this particular case, the Act fails to provide for any definition clause as to what amounts to derogation, what amounts to disrespect of women in general. This creates a chilling effect on the members of Zatali community as they are not clear of what conduct is prohibited and what is not prohibited. Therefore, Your Lordship's lack of interpretational standards would open gateways for misuse of the Act and as well would leave the members of Zatali community under a chilling effect with respect to their freedom of expression. Another limb is that the Act also fails to mention the requirement of mens rea, Your Lordship. The Shreya Singhal case also referred to the case of Mithu versus State of Punjab decided by the apex court to state that for any law, especially when the law is a penal law that curtails expression, mens rea is essential. Otherwise, there will be no distinction between laws, derogatory expression made intentionally and those who are done innocently. Therefore, Your Lordship, the Act is also void due to its vagueness. The other limb of this council is that the Act is violative of Article 19 of the Constitution as it provides the unreasonable restriction on freedom of expression. Your Lordship, the Supreme Court in N.K. Bajpai versus Union of India stated that restriction to freedom of expression must be placed on the principle of least invasiveness. Further, Your Lordship, the Supreme Court in N. Radhakrishnan versus Union of India stated that any curtailment of expression, unless derogatory for abject obscenity, goes beyond intellectual tolerance and might amount to intellectual cowardice, annihilating freedom of expression in total. In the instant case, Your Lordship, the Act prohibits derogatory expressions in general. There is no, as mentioned by the Supreme Court in N. Radhakrishnan versus Union of India, wherein the court made a classification between derogatory expressions and derogatory expressions capable of mishappening the public order and derogatory expressions which can attribute to obscenity. There is no such classification made in this particular Act. Again, as pointed out in the Shreya Singhal case, there is no classification between derogatory expression and derogatory expression that might amount to defamation, as an essential element of defamation is reputation. There is no classification between fictional and non-fictional expressions in this particular Act as well, Your Lordship. Furthermore, Your Lordship, the Act does not talk about derogatory expression that might amount to incitement to an offence. Shreya Singhal case also classified three stages that exist in expression. First is discussion, second is advocacy, and third comes incitement to an offence. 19 clause 1 protects the first and second stage, discussion and advocacy. 19 clause 2 comes into play only when the third stage comes into question, that is incitement to an offence. This particular Act curtails all forms of expression, including discussion as well. With this, the Council would like to move on to the second issue of the argument.
Defamation is an individual right, it is not. Defamation is an individual right. I mean, getting it for the community.
Indeed, Your Lordship.
Be able to understand that.
Indeed, Your Lordship. The Council would like to state that if it were the intent, if the Union of Indica is trying to justify this particular Act by telling that it is one needed for prohibiting defamation, then there must be a classification between fictional and non-fictional expression mentioning the need for the reputation, Your Lordship. With this, the Council would like to proceed to the second issue, that is whether there exists hierarchy in the idea of fundamental rights. Your Lordship, the Council submits that there indeed exists hierarchy in the idea of fundamental rights, and this submission is advanced on two grounds. First, right to life holds supremacy over all the other fundamental rights. Second, Article 25 is subject to other fundamental rights mentioned under Part 3 of the Constitution. So far as the first limb is concerned, Your Lordship, the Supreme Court in Justice K.S. Puttaswamy versus Union of India affirmed the supremacy of right to life over other fundamental rights, and the court also upheld the correctness of the dissenting judgment of Justice H.R. Khanna in the case of ADM Jabalpur versus Shivkant Shukla, wherein he states, right to life and personal liberty is the most precious right, Your Lordship. This justifies the supremacy of Article 21 over other articles in the Fundamental Rights. Proceeding to the second limb of the issue, Your Lordship. Article 25 is subject to other provisions under Part 3 of the Constitution. Your Lordship, the Supreme Court in Indian Young Lawyers Association was a state of Kerala observed that dignity, equality, and liberty stand above even when confronted with religious belief. Your Lordship, the very verbatim of Article 25 begins with the statement subject to other provisions of this part. This subjugation clause was deliberately intended by the framers of the Constitution as it is very unique to the Indian Constitution alone. Although India borrowed its freedom of religion from other countries, the United States Constitution does not have a subjugation clause to its freedom of religion. The UDHR Article 18 of Declaration of Human Rights does not have a subjugation clause to religious freedoms. Therefore, Your Lordships, the framers of the Constitution very deliberately inserted a subjugation clause to Article 25, and therefore the supremacy of Article 21 and subjugation of Article 25 connotes a hierarchical scheme in the idea of fundamental rights, Your Lordship. Now, if the court is satisfied, the council would like to proceed to the third issue. Much obliged. The third issue is whether the author's exercise of right to freedom of speech and expression has violated the general standard of decency or morality. Your Lordship, the council submits that the author has not violated the general standard of decency or morality. Two verses of this particular poem written by Mr. Marwadan is relevant in this particular case. One is the verse where he describes the beauty of a female fictional character, and another is where he describes a sexual act in which she participated with her paramour. Your Lordship, the councillor contends that the said poetic expressions made by the author does not exceed the scope of Article 19 Clause 2 and they form within the legitimate domain of expression mentioned under 19 Clause 1, and this contention is substantiated on two grounds. First, description of sexual act does not amount to obscenity. Second, describing the beauty of a fictional character does not violate the general standard of decency or morality. Proceeding with the first limb, Your Lordship, the council submits that sex in literary form does not amount to obscenity per se. The Supreme Court, in the case of Avik Sarkar was the state of West Bengal, stated that the court dictated the community standards test and stated that general standards of decency are immoral. Subsequently, in 1985, the Supreme Court went to the extent of stating, in the case of some Supreme Court judgments in this regard, as stated earlier in the case of N. Radhakrishnan, Justice Deepak Mishra, then Chief Justice of India, has provided enough importance to the creative voices. He states that creative voices cannot be stifled